Hello everyone, welcome to MastersTeach, and today we are going to discuss intellectual property law. It is a part of your fourth sem and fifth paper of LL.B. We are going to discuss about the meaning, nature, scope, and objectives, and we look after patents, copyright, trademark, designs, etc. Okay, listen carefully so that you are going to pass very easily in your semester exams. So let us start. What is intellectual property? Okay, what is IP? You can say that it is a creation of mind protected by law, giving creators exclusive rights over their work. Okay, so the nature it is intangible. That means you cannot touch but you can feel. It is a territorial. It is a time limited. That means it cannot be touched. However, you can feel. It is a territorial. It has the border. Within that limit, it works. Then limit. Certain time will take for the same. Why it is need? The intellectual property. Why it is need? In order to have like innovation and in order to prevent the misuse of original work. Okay, so the types of intellectual property, uh, it is patent, trademark, copyright, design. These are the types of intellectual property rights. Patent, example, you can say that any drug formula. Trademark, Nike. Okay, copyright for any novel. Design, so bottle shape. These are the intellectual property types. Let us see types of intellectual property. Okay, so patents. Okay, for example, patent, trademark, copyright, GI tag, industrial design, trade secrets. What is patent? So it is the inventations and process. For example, paracetamol. Trademark. So it shows about the brand identity. Copyright, so related to the literary work or books, artistic works, it comes for the example novel. Then GI tag, it is the geographical origin. For example, Darjeeling tea and Telangana paspu. Okay, then industrial design, so it is the like aesthetic features. There is a separate design. For example, bottle shape. Then trade secret, it is a confidential business information. Example, Coca-Cola formula. Still, it is not revealed. So these are the types of intellectual property. Okay, patents, trademark, copyright, GI tag, industrial design, and trade secret. Okay, let us have new form of intellectual property rights. Okay, as the days changes, so the intellectual property also got changes. So here the new form, it may be plant varieties, biotechnology, GRITK, that is a traditional knowledge. Then it comes to layout design, that is a microchip. Then computer program, that is related to software, artificial intelligence. So these are the new form of intellectual property rights. If somebody asks what is a new form of uh, intellectual property forms, that is a plant variety, biotechnology, GRTK, then layout design, computer program, artificial intelligence. So these are the new forms of intellectual property rights. Okay, so new form, for example, plant variety. Example, hybrid seeds. Biotechnology, it is GMO crops. GRTK, there is a neem, turmeric, something like that. Then layout design, microchip, computer programs, Windows operating system, artificial intelligence, that is the AI generated art. So these are the new technology and new IPO forms. Let us go to the next slide. Traditional protection, traditional IP protection timeline. We'll discuss. Here, international IP protection timeline. How it is taken place. In 1883, there is a Paris Convention where they discussed about the patents and trademarks. In 1886, Berne Convention, okay, it is discussed about the copyright, and 1891 Madrid Agreement, they discussed about the trademark registration. Then in 1967, there is a WIPO, okay, there is a World of Intellectual Property Organization established in 1967. In 1970, there is a PCT, so there is a establishment of Patent Cooperation Treaty, and in 1994, TRIPS, okay, there is a World Trade Agreement. So they may ask in the examination international IP protection timeline or history. That time you have to mention these things. Let us go to the next slide. Okay, Paris Convention 1883. So there is a convention happen in Paris that is called Paris Convention 1883. The key principles are national treatment. So in any country, foreign nationals treated equally. Then priority right, 12 months patents and 6 months marks. Then common rule, minimum protection standards. For example, an Indian inventor filing in France gets the same rights as a French citizen. So in Paris Convention 1883, what they cover? They cover about the patents, trademarks, industrial design, and GI. Then, how many members are there in the Paris Convention? There are 179 countries, including India. So, who is administered this? There is the World Intellectual Property Organization, which is in Geneva. This is about the Paris Convention 1883. Let us go to the next slide. So, Berne Convention. Okay. So, what it is that? So, the core principle, there is a automatic protection. So, there is no uh, registration required. Okay, as per Berne Convention. Second, minimum standard. So, there is a life plus 50 years. Authors rights. So, more and economic rights. So, these are the Berne Convention 1986 support for copyright protection for books, songs, and films. So the core principles of Berne Convention. Okay, there is a automatic protection. Okay, no registration is required. Then minimum term life of author plus 50 years moral rights attribution and integrity national treatment equal protection abroad. So this Berne Convention 1886 example, so it is related to book, songs, film, so which is protected automatically upon the creation. So there is no registration is required. So the validity of patent, there is a Berne Convention 1886. As per that, the person who created the song or book or film, they'll have the rights up until their end of their life and plus 50 years. Then, so author's rights, so moral and economics rights will be given. So this Berne Convention 1886 supporting copyright protection for books, songs, films. Okay, let us go to the next slide. Then WIPO, WCT, and TRIPS. So the organization, it is WIPO, okay, which is established in 1967. The key functions are that administrative IP treaties globally, the impact India member since 1975. Then WCT, it is in 1996. The key function of WCT is that copyright in digital environment. And what is the impact? So software and internet protection. Then TRIPS, which is established in 1994, minimum IP standards under WTO. Okay, so what is the impact? It is the amended Patents Act 1970. What is TRIPS? It is a trade related aspects of intellectual property right. Uh, is the most comprehensive multilateral IP agreement. Let us go to the next slide. Copyright law. So, what is the meaning of copyright law? So, which is exclusive for the creator, for the original literary, artistic, and dramatic works. So, what is the nature of getting copyright? It is automatic, it is intangible, it is territorial, and time limited. What is the objective of copyright law? It protects the creators, promote creativity, balance public access. Example copyright law. For the example, you have to remember any movie, book, software, music. So it is protected under Copyright Act 1957. This is about the copyright law. Let us go to the next. Okay, Copyright Act 1957. And what is the silent feature? So it is idea versus expression. Only expression is protected, not the underlying idea. So the subject matter, Copyright Act 1957, like literary, dramatic, musical, artistic works, films, sound recording, and neighboring rights. So rights to the performers, broadcasters, and producers. So the term for this Copyright Act 1957, life plus 60 years. Example for the Copyright Act 1957, work protection, it is a music, so which includes composition and recording, painting, so it is a artistic work, film, it is a cinematograph film, then software, literary works. This is the Copyright Act 1957 and its silent features. Let us go to the next. Ownership and infringement remedies. So owner, the author is the first owner. Employer owns work made in course of employment. So assignment and licensing, rights can be assigned or licensed. It is a collective management organization, that is a CMO, manage rights. The fair use exceptions, so this like fair use and exception, education, research, criticism, new reporting, etc. So it is the photocopy of study. Okay, remedies, it is for the civil injunction, damages, criminal. So those who are like default about this, or those who uses misuses, they'll get the civil injunction and damages, criminal imprisonment or fine, and administrative purposes. Let us go to the what is trademark. A trademark is a sign capable of distributing goods and services of one enterprises from another. Okay, so the trademark purpose is that, so you're going to identify the origin, guarantee quality. Okay, then advertise. So trade description, it describe about the nature, quality, origin of goods. So this trademark is governed by the Trademarks Act 1999. So the example for the trademark, Apple logo, Nike, the word plus device mark, Amul, it is the brand mark. So importance, so the consumer protection and brand value. This is about the trademarks. Let us go to the next slide. Types of trademarks. Okay, here the category, type and example. So conventional example where it is word, logo, device, label. So these are the convention. Example for the conventional trademark: Amul, Nike, Swatch. Then non-conventional about the shape, marks. For example, Coca-Cola bottle shape. Okay, non-conventional about the color marks. So Cadbury is the purple, ICICI Bank it is something different, and HDFC Bank it has blue and white on red. Then non-conventional it is about the sound marks. So for example, Intel jingle. So digital it says about the dominion names yahoo.com. So non-conventional marks face higher registration hurdles, so they must provide proof distinctness through use. So these are the types of uh, trademarks. Okay, then let us go to the uh, basically this is divided into three types: conventional, that is word, logo, device, label. Okay, non-conventional shape, marks, color marks, sound marks, these are the non-conventional. And digital it is about the dominion names .com, .net, usa, .net, something like that. So this is the thing, types of trademarks. Just listen. Okay, it is just reading and it is help you to uh, like pass in your exams. Let us have how the trademark registration and infringement. Okay, so first you have to apply, second it is going to be examined, then it is will be published. Then if something is there within 4 months one can oppose the same. Then if that opposition get clarified, then registration will be granted. So registration under Trademark Act uh, 1999. So it confers exclusive rights for 10 years. It is the renewable indefinitely. So what is infringement and remedies? Infringements authorize use of identical or similar mark. So how this can be passed off? They have the common law remedy. No registration is required. Remedies. So somebody misuse that one. What happens? So injection orders will be given, damages and accounts of profit will be shared. This is about the trademark registration and infringement. Let us go to the next slide. Industrial design. So let us discuss in industry, like they are going to give the patents for the any bottle shape for Coca-Cola, etc. Design. So EM's chair aesthetic. Then the duration 10 years plus 5 renewals. So what is the meaning of industrial design? A design refers to the aesthetic features of shape, configuration, pattern, ornamentation, or composition of lines, colors applied to an article. So the industrial design IP can be given. It must be a new and original one. It is applied to the article by industrial process. It is governed by the Design Act 2000. The copyright design in design, it is once registered, design is protected as a copyright. Okay, there is an industrial design. Okay, that you have to remember. Then let us go to the next slide. Designs Act 2000. Registration rights. How the registration can be happen as per the Designs Act 2000. First you have to give the application, then it is going to be they examine the same. If the objections is there, that you have to verify, that you have to rectify, then registration, then they are going to give the certification. So what is the rights will be given? So through this Designs Act 2000, so they're going to have exclusive right to apply design to articles. So right to sue infringement. So if somebody doing some piracy, then you can sue in the court. What is the remedies? Okay, so injunctions order will be given. So if the damage happen, 50,000 will be penalty. Then they may cancellation of high courts or controller. This is about the Design Act 2000, registration and rights. Let us go to the next slide. Patent law. Okay, meaning it is exclusive right granted for a new and usable non-obvious invention. Okay, Patent Act 1970 says that which is amended in 2005 as a TRIPS compliance. So product patents restored, then patentable. So drug, machine process, example paracetamol synthesis, then not patentable, so which cannot be under comes under patentable. Okay, for example, discoveries, mathematical methods and traditional knowledge. This is about the patent law. Then let us go to the next slide. Patent grant procedure. How the patent can get the grant. Okay, how the process can be, patent can get the uh, thing. Let us discuss. So the patent grant procedure, first you have to apply, then it is going to be published, then they will examine, then there is a opposition. So like this it's happened. Let us go to the next slide. Okay, rights and limitations and infringement. Okay, rights of patentee. So they can make, they can use, they can sell or import patent product. For example, drug manufacturer. Compulsory licensing. For example, Section 84. After 3 years, public interest and non-working. So, Nexaver cancer drug 2012. Then government acquisition. Section 102 for the public purpose with compensation. For example, defense technology. Then secrecy direction. So, Section 35 which says about the for national security for the military invention. Then infringement remedies, injection damages account of property. Example, technological disputes. Let us go to the what we are learned. We learn the patents. Okay, it is there for 20 years. The Patent Act 1970, for example, drug. Then trademarks, 10 years plus 10 years. So Trademarks Act uh, 1999. So example Nike. Then copyright, it is a lifetime plus 60 years. So the Copyright Act 1957. For example, book. And the design. So they have 10 plus 5 years. So the Design Act 2000. Example, bottle shape. Then TRIPS and WIPO. So 1994 and 1967. It is a international framework. So what you have to remember the key doctrine: fair use, passing of compulsory licensing, PCT. So this is a small reading or presentation. Go through this video again and again so that the success rate will be higher. Thank you for listening my class. All the best for your coming examination. Signing off, your Mohan. Thank you.